Imagine, if you will, you are going to prosecute a former president. You know it's going to be contentious, unpopular even. It's going to be a knockdown, drag-out fight. So of course, you're going to be as careful as possible. You take every possible step to avoid conflicts of interest because you know that you're going to be under a microscope. Well, you, my friend, are not Fulton County District Attorney Fani Willis, who apparently did none of those things. Our resident prosecutor Spencer the Scowl Owl will unpack this entire cluster debacle and explain how it turned into a giant soap opera.
Like sands through the hourglass, so are days of our lives. Fulton County edition. The legal soap opera whose writers jumped the shark 2 seasons ago. It's like Lost and Suits got together and made a terrible, ugly baby. You've got sex, money, power, betrayal, and vengeance. Allegedly. Let's remind ourselves of the cast of characters. Fulton County District Attorney Fani Willis, elected in November 2020 and serving since January of 2021. And for what it's worth, running for re-election in November 2024. Nathan Wade, one of 3 special prosecutors Willis hired in November 2021 to handle the Trump election fraud RICO case. And former lover of Fani Willis, Terrence Bradley, an attorney and former law partner with Nathan Wade, who represented Wade in Wade's divorce proceedings, but who also separated from his legal partnership with Wade after an allegation of sexual harassment. Michael Roman, one of the RICO defendants and former director of Election Day operations for the Trump 2020 campaign. Ashley Merchant, defense attorney for Michael Roman and friend and confidant of Terrence Bradley. Robin Yurdy, a former friend of Willis's who was essentially told she had to resign from the DA's office or would be fired for unspecified reasons. Donald Trump.
I get along with everybody.
And finally, Scott McAfee, the judge presiding over the RICO case and lover of his wife, probably? I mean, he seems pretty normal. Oh, and there are a ton more. Supporting cast. Through his lawyers, Michael Roman alleged that Willis had a romantic relationship with Wade and hired Wade in an elaborate kickback scheme to enrich herself. Roman filed a motion to disqualify Willis, her office, and the Fulton County District Attorney's Office from further prosecuting this matter. The motion also sought dismissal of the indictment, but that was like the Hail Mary that really only had a chance if the evidence developed extremely favorably. Trump's lawyers and other defendants joined the motion and added to it, threatening to derail the entire Fulton County case. The motion to disqualify accused Willis of violating laws prohibiting conflicts of interest and nepotism. At the time the motion was filed, the facts about the relationship between Willis and Wade were sparse. Before Nathan Wade was appointed as special prosecutor, he had never led a high-profile criminal case and had largely worked as a suburban defense lawyer and municipal judge. But Wade was paid well over $500,000 for his work as special prosecutor. And then the bombshell allegation that Wade and Willis were lovers, and he spent some of the money he earned on Willis, taking her for lavish dinners and vacations. In other words, a kickback scheme. The allegations came to light after Wade filed for divorce. When his wife started the process of uncovering his assets, Wade ignored discovery orders and was held in contempt of court. Oh, and by the way, Wade filed for divorce the day after he started working as a special prosecutor for Fulton County. Willis didn't deny having a relationship with Wade. Instead, she went to a historically black church and gave a speech decrying the inquiry as racist.
I appointed 3 special counsel, as is my right to do, paid them all the same hourly rate. They only attacked one. I hired one white woman, a good personal friend and great lawyer. A superstar, I tell you. I hired one white man, brilliant, my friend, and a great lawyer. And I hired one black man, another superstar, a great friend, and a great lawyer.
She noted that the other 2 special prosecutors, who were white, weren't subjected to any scrutiny. Eventually, Judge McAfee held an evidentiary hearing over multiple days, and boy, was it something. Wade testified that he met Willis in 2019 at a conference, and they became friends. His romantic relationship with Willis started after his appointment as special prosecutor sometime in early 2022. He testified that when he went on trips with Willis, he would pay with his card because she was concerned about her safety, but that she would reimburse him for her portion in cash. He also testified that he wasn't dating anyone in 2020 because he was focused on a cancer diagnosis. Yet Wade's credibility took a pretty big hit. He was questioned about his answers to interrogatories filed as part of his ongoing divorce case. A May 2023 interrogatory asked Wade to disclose any sexual relations he had during his marriage, including during the time of separation and up to the present. He responded, none. Another interrogatory asked Wade to identify any and all occasions in which he entertained a member of the opposite sex from date of marriage to the present. Wade again answered, none.
When did your romantic relationship with Miss Willis begin?
2022.
When in 2022?
Early 2022.
Both answers were, of course, utterly false. Wade tried to explain that his marriage was irretrievably broken in 2015, and so he didn't consider anything after 2015 to be during his marriage, despite the fact that he was still legally married, and the interrogatories clearly stated from the date of marriage to the present. The law has a technical term for this. Willis's testimony about the relationship largely tracked Wade's. When questioned about her reliance on cash, she explained that she always has cash on hand in her house. She said her father taught her to always have at least 6 months of cash around at all times, and to always have $200 in your pocket on a date, so that if a man acts up, you can go where you want to go.
When you meet my father, he's going to tell you as a woman, you should always have, which I don't have, so let's don't tell him that. You should have at least 6 months in cash at your house at all times. If you're a woman and you go on a date with a man, you better have $200 in your pocket. So if that man acts up, you can go where you want to go. So I keep cash in my house.
And Willis testified that her relationship with Wade ended in the summer of 2023, not because of the prosecution, but because they had different views on gender equality.
Mr. Wade is used to women that, as he told me one time, the only thing a woman can do for him is make him a sandwich.
John Floyd, Willis's father, largely corroborated Willis's testimony, both about the cash and about the timing of the relationship with Wade.
Your Honor, I'm not trying to be racist, okay? But it's a black thing, okay? You know, I was trained, and most black folks, they hide cash or they keep cash.
He testified that he didn't meet Wade until 2023, but that he did meet the boyfriend Willis dated in 2019 and 2020, who frequently visited the home Floyd shared with Willis at the time. He was a disc jockey or something, and Floyd nicknamed him Deuce. According to Floyd, Wade was never at the house during the period that Floyd lived with Willis from 2019 to 2021, unlike Deuce. Then came Robin Yeardy, the former friend. Yeardy testified that she and Willis met in college and became good friends for many years. Following Willis's election in 2020, Yeardy accepted a non-attorney position at the DA's office. Yeardy agreed that Willis and Wade met at a 2019 judicial conference, but according to her, they began a romantic relationship shortly thereafter. Yeardy testified that Willis told her about a romantic relationship with Wade prior to Wade's appointment as special prosecutor. Yeardy also said that she had no doubt in her mind that Wade and Willis were in a romantic relationship from 2019 to 2022.
And do you understand it that their relationship began in 2019 and continued until the last time you spoke with her?
Yes.
And Yeardy said that prior to Willis's election, she observed Wade and Willis hugging, kissing, and being affectionate with one another. Yet on cross-examination, Yeardy inexplicably couldn't remember details about what Willis said and when. Even worse, Yeardy acknowledged that she was let go from the DA's office under a cloud.
A situation happened that wasn't my fault, and I either was going to resign or be let go.
According to Yeardy, the circumstances under which she left the district attorney's office ended her friendship with Willis, and the two haven't spoken since. Finally, Terrence Bradley. Oh, Terrence. Bradley testified that he first developed an attorney-client relationship with Wade in 2018. Around that time, Wade approached Bradley for legal advice as he considered filing for divorce from his estranged wife, although Wade didn't ultimately file for divorce until 2021. Bradley then cited attorney-client privilege, saying he possessed no non-privileged personal knowledge related to Willis and Wade's romantic relationship. Both Wade's personal attorney and the DA's office repeatedly invoked the attorney-client privilege to prevent Bradley from answering further questions. Yet Ashley Merchant was able to cross-examine Bradley on some damning text messages and emails. Merchant texted Bradley, "On information and belief, Willis and Wade met while both were serving as a magistrate judge and began a romantic relationship at that time. Is that accurate? Bradley responded, no, it was municipal court. Well, regardless of whether it was a magistrate or municipal judgeship, that sure seems to imply that the romantic relationship started before Willis was DA, in other words, before November 2020. Merchant also had an email that she sent Bradley just days before she filed her initial motion to disqualify, which alleged that Willis and Wade were involved prior to his appointment as a special prosecutor on November 1st, 2021. Her email to Bradley included a copy of the motion that she ultimately filed. Bradley responded, looks good. And what makes this all the worse, at the beginning of his testimony, Bradley testified that he never directly communicated with Merchant about Willis and Wade's relationship. Ugh. Does it get worse for Bradley? Oh, yes, sir. Bradley was previously Wade's law partner. On direct examination, Bradley said he left the partnership because he wanted to leave and go out on my own. But he also admitted that he had a disagreement with Wade. He refused to go into the specifics about that disagreement, though, saying it was privileged as it related to his representation of Wade in the divorce case. On cross-examination, however, Bradley admitted that an employee of the firm accused him of sexual harassment, and as a result of that allegation, he left the firm.
Mr. Wade brought to your attention the sexual assault allegations that you've been asked about by the prosecutor, correct?
Correct.
And at that time that Mr. Wade brought those allegations to your attention, you were still the attorney for Mr. Wade, correct?
Correct.
And therefore, your conduct as an attorney, and the attorney at that time for Mr. Wade, was called into question by Mr. Wade's passing along to you allegations of misconduct, correct?
After all the evidence was heard, Judge McAfee heard closing arguments. The defendant settled more or less on 3 bases for disqualification. 1, Willis's personal financial conflict of interest in hiring Wade and then getting financial benefits in return. 2, the speech at the church. And 3, Willis's conduct in defending against the motion to disqualify, including alleged perjury on the parts of Willis and Wade. Did it end there? No. After closing arguments, Trump's attorney, Stephen Sadow, tried to supplement the record with an affidavit from a private investigator. They subpoenaed AT&T to get call and text records as well as location information of Wade's phone throughout 2021. Analyzing that data, the private investigator said there were at least 35 occasions when Wade likely visited Willis and at least 2 occasions where he apparently spent the night. And this was all before Wade and Willis testified their relationship began. Then on March 4th, co-defendant David Schaefer's attorneys filed a motion asking Judge McAfee to reopen the hearing and hear additional testimony. According to the attorneys, Cindy Yeager, co-chief deputy district attorney for the Cobb County District Attorney's Office, had numerous in-person conversations with Terrence Bradley about Willis and Wade's relationship. According to Yeager, Bradley told her in no uncertain terms that Willis and Wade's romantic relationship started while Willis was running for district attorney in 2019 and 2020, and that they used Robin Yurdy's condo prior to 2021. After watching Bradley's televised testimony, Yeager became concerned that Bradley's testimony was directly contradictory to what he told her, and she felt obligated to disclose what she knew.
Now, if I can interject for a moment, if you find yourself defending the propriety of your prosecution, you'd probably want a good lawyer. But if you want a great lawyer, my firm, the Eagle team, can help. If you've suffered an injury or death in the family, got in a car crash, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can get the best representation and find out what your options are from the very beginning. So just click on the link in the description or call the number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. You can click on the link below.
Okay, let's all take a deep breath. Let's talk about the law of prosecutorial disqualification. Disqualification in Georgia can happen 2 ways. First, a prosecutor can acknowledge a disqualification at the outset. That's not uncommon, it happens. If the DA's son is the victim of a crime, that DA may just say, my office isn't going to handle this. Second, a defendant can file a motion and a court can then order that a prosecutor is disqualified. There's also the issue of scope. Sometimes it's enough to disqualify an individual prosecutor and remove them from the case. But sometimes an entire district attorney's office is disqualified. When an entire office is disqualified, the district attorney is required to notify the prosecuting attorney's counsel of the state of Georgia and that counsel is tasked with finding a replacement. Now, judges can be disqualified too. Interestingly, the bar for disqualifying a judge is arguably lower than that for disqualifying a prosecutor. Judges are supposed to be neutral and unbiased in each case, avoiding even the appearance of impropriety. Prosecutors, on the other hand, aren't just allowed to be unbiased, it's literally in their job description. 100 years ago, the Georgia Court of Appeals said this: "While the prosecuting officer should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial functions in the case are the judge and jury. The public prosecutor is necessarily a partisan in the case. If he were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals." But imagine I said all that in a good old boy accent. For a prosecutor, disqualification is only required under Georgia law when a personal interest is so strong that a prosecutor appears to be acting for his personal or individual interest rather than in his character as an officer of the law. There are two generally recognized grounds for disqualification of a prosecutor under Georgia law. First, a conflict of interest, and second, something called forensic misconduct. Forensic misconduct includes things like evidence tampering, but it would also include public statements by a prosecutor designed to prejudice a defendant in the minds of potential jurors, or a prosecutor injecting their own personal opinion about the guilt of a defendant during closing arguments. In this vein, Steve Sadow, Trump's attorney, alleged that Willis's speech at the church constituted forensic misconduct. A conflict of interest may arise when the prosecutor has acquired a personal interest or stake in the defendant's conviction. A conflict of interest requires more than a theoretical or speculative conflict. It has to be an actual conflict. And I'm about to bake your noodle. Actual does not really mean actual. An actual conflict just means that there's a strong possibility that conflict might arise. The stage is set, but the actors don't have to be on scene. The whole point of disqualifying someone when there's an actual conflict of interest is to prevent the conflict of interest from materializing in the first place. There are a few basic categories of conflicts of interest that have led to prosecutorial disqualification in Georgia in the past. First, and probably pretty obviously, there's usually a conflict of interest if a defense attorney switches sides and prosecutes his former client. Second, a prosecutor is disqualified if she's a fact witness against the defendant. Third, a prosecutor is disqualified if she has a close personal relationship with a victim. Fourth, and finally, a prosecutor can't have a personal financial stake in the outcome of the prosecution. For example, if a prosecutor is paid by a contingency arrangement, where they only get paid if there's a conviction, the prosecutor is disqualified because the fee arrangement creates at least the appearance of a conflict of interest between his public duty to seek justice and his private right to obtain compensation for his services. The unifying theme behind these categories is that a prosecutor must not seek a conviction for an improper purpose or using improper means. If a prosecutor could switch sides to prosecute a former client, for example, she would have inside information that could potentially violate the defendant's right to a fair process. Similarly, if the prosecutor has a financial interest in the conviction, then this conflicts with a prosecutor's duty to seek justice. If a prosecutor is a close personal friend to a victim, this conflicts with the prosecutor's duty to seek public justice rather than resolve a private vendetta. Now, this whole thing isn't the first time we've seen disqualification in this case. Willis and her entire office were disqualified from prosecuting Lieutenant Governor Burt Jones as part of the 2020 election conspiracy because the two had a political rivalry. When Jones moved to disqualify Willis, he was the target of a grand jury investigation into the facts of this case. Jones was serving as a state senator and was the Republican nominee for lieutenant governor. Willis had endorsed his opponent and held fundraisers for the Democratic candidate. Judge McBurney ruled that this was a clear conflict of interest warranting disqualification. Judge McBurney concluded that this choice, which the district attorney was within her rights to make, has consequences. She has bestowed her office's imprimatur upon Senator Jones's opponent, and since then, she has publicly, in her pleadings, labeled Senator Jones as a target of the grand jury's investigation. This scenario creates a plain and actual and untenable conflict. Any decision the district attorney makes about Senator Jones in connection with the grand jury's investigation is necessarily infected by it. Judge McBurney agreed that with respect to Senator Jones, Willis's prosecution looked suspect, because any effort to treat Jones differently from other subjects of the investigation, even if justified, will prompt entirely reasonable concerns of politically motivated prosecution. Is Senator Jones being singled out because of a desire to further assist the Charlie Bailey campaign? The judge ruled that any investigation of Senator Jones would benefit Willis's preferred candidate, so she was disqualified from prosecuting him. But wait a second. How does that fit into the categories that have led to prosecutorial disqualification in the past in Georgia? Well, while it's not a financial stake, Judge McBurney clearly thought that Willis obtained some improper personal benefit from prosecuting Senator Jones. That's enough, according to Judge McBurney, for an actual conflict under Georgia law. But Judge McBurney also said something interesting in a footnote. A mere appearance of impropriety is generally not enough to support disqualification, except in the rarest of cases. This is one of those cases. Remember, kids, always read the footnotes, because in this case, Judge McAfee certainly did. You see, while the hearing was going on, the lawyers focused most of their time on details of Willis and Wade's relationship, from when it began to who was paying for what. Judge McAfee, though, seemed caught up in what standard he should be using to decide disqualification. Where does the appearance of impropriety fit in? In 2017, the Georgia Supreme Court addressed the issue of whether a district attorney should be disqualified in a murder case. In Battle v. State, the murder victim's mother was a longtime employee of the district attorney's office. When the defendant argued that the DA's office should have been disqualified on that basis, the court said this: "Certainly, a conflict of interest or the appearance of impropriety from a close personal relationship with the victim may be grounds for disqualification of a prosecutor. But here, there was no evidence that either the district attorney or the assistant district attorney directly prosecuting the case had any conflict of interest or a personal relationship with the victim or his mother, or any personal interest in obtaining the sought convictions." If you read that closely, it looks like the Georgia Supreme Court distinguishes two different grounds for disqualification: conflict of interest and the appearance of impropriety. And the court seems to view the relationship between the DA's office and the murder victim's mother as falling more under the appearance of impropriety category rather than a potential conflict of interest. And that's exactly how McAfee took it. McAfee issued his ruling on Friday, March 15th. He found that the defendants failed to meet the burden of proving that the district attorney acquired an actual conflict of interest in this case through her personal relationship and recurring travels with her lead prosecutor. McAfee noted that paying Wade by the billable hour is unexceptional and common in the legal profession, and also that the $250 per hour rate was relatively low for Atlanta given Wade's years of experience. Wade was limited to 60 hours of work per month unless he received permission to work more, and there's no evidence that Wade ever received such permission. And perhaps most importantly, McAfee pointed out that Wade wasn't Willis's first choice. She had offered the special prosecutor job to former Georgia Governor Roy Barnes first, but he declined.
I told D.A. Willis I'd lived with bodyguards for 4 years, and I didn't like it, and I wasn't going to live with bodyguards for the rest of my life.
McAfee spent numerous paragraphs in his order looking at Wade and Willis's travel and expenses. In the end, he concluded that there just wasn't enough evidence to say that Willis hired Wade in a kickback scheme, or that Willis was motivated to indict and prosecute the case because she had an interest in financial gain. Now, that's not to say that McAfee took Willis and Wade's reimbursement practice at face value. He acknowledged that the practice may be unusual and understandably concerning. Most damning, McAfee described the whole affair as a tremendous lapse in judgment, and described Willis's testimony as unprofessional. While he couldn't find an actual conflict of interest, McAfee pointedly said other forums or sources of authority, such as the General Assembly, the Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Board of Commissioners, or the voters of Fulton County, may offer feedback on any unanswered questions that linger. Ouch. Regarding Willis's church speech, McAfee did find that it was legally improper. According to him, the effect of this speech was to cast racial aspersions at an indicted defendant's decision to file the motion to disqualify. But the speech didn't rise to the level of forensic misconduct because it didn't specifically mention any defendant by name. It didn't disclose sensitive or confidential evidence, and it was too far removed to permanently taint the jury pool. That said, McAfee hinted that he might sign a gag order if the defendants were to ask for one. Now we get to the appearance of impropriety. McAfee pulled no punches. He excoriated Wade's patently unpersuasive explanation for the inaccurate interrogatories that he submitted in his divorce case. And he said a member of the public could reasonably think that the district attorney is not exercising her independent professional judgment totally free of any compromising influences. Even though the defendants failed to prove Willis and Wade lied under oath, according to McAfee, an odor of mendacity remains, and there are reasonable questions about whether they testified untruthfully. All of that, according to McAfee, leads to a significant appearance of impropriety that infects the current structure of the prosecution team. McAfee then gave Willis two options. Either Wade goes, or you and your entire office do. Wade resigned hours later. So what does this mean for the Fulton County election interference case? Willis opted to have Wade resign, so her office is still prosecuting the case. If she hires another special prosecutor, it'll take some time to get that special prosecutor up to speed. But the big issue will be an appeal. Willis is unlikely to appeal McAfee's order since she wasn't disqualified. But the defendants can and most likely will try to appeal the order. It'll be up to Judge McAfee whether to allow an appeal right away or have it wait until after trial. McAfee would have to grant what's called a certificate of immediate review. If McAfee grants immediate review, that would start an appellate process that is really not well known for its speed. And that may be the whole point for some of the defendants, or let's be real, one specific defendant. Delay the trial until after the 2024 election.
Yeah, so everything looked terrible because it all looked incredibly stupid, but as Judge McAfee ruled, quote, in sum, the district attorney has not in any way acted in conformance with the theory that she arranged a financial scheme to enrich herself or endear herself to Wade by extending the duration of this prosecution or engaging in excessive litigation. So it's bad, but not disqualifyingly bad. Now, whether you believe Fani Willis about paying for her expenses in cash or not, we can all agree that it would have been way better for her budget to keep track of her expenses with today's sponsor, Rocket Money. Then at least she'd have some proof. Sometimes the sponsor segues just write themselves. Now, unlike Fani Willis, I never use cash, but recently I had a problem trying to get a handle on all my subscriptions. Between my personal and professional subscriptions, I was paying out almost $20,000 a year. Yeah, it turns out being an attorney is extremely expensive. Now, I hadn't been paying too much attention to what I was subscribed to, and once I started to track my expenses, it was insane how much money I was spending on monthly services I subscribed to a while ago and totally forgot about. But Rocket Money is an all-in-one finance platform that helps me be smarter about how I'm spending my money. It's a personal finance app that allows me to manage my subscriptions, lower my bills, and budget appropriately all in one place. And now that Mint.com is shutting down, it's a wonderful replacement. I'm currently using Rocket Money to help me cancel all the subscriptions I wasn't using for apps I didn't need anymore now that Succession is over. Plus, it told me recently that a service increased their price by $100 per year. I should really be looking into that instead of reading this ad. But Rocket Money has helped save its customers up to $740 a year with over $500 million in total canceled subscriptions. It does that in part by fighting for lower bills. You can simply upload a photo and tap a button, and Rocket Money will negotiate your bills for you, from internet service bills to cable and phone bills. So join the 5 million members using Rocket Money today. You can click on the link in the description or on screen to get started for free. You can also unlock even more features with Premium. Again, just click on the link below to get started for free. After that, click on this link over here for more LegalEagle, or I'll see you in court.